Okay. So we were just talking while we were listening and said, the Glenn Fitzmartin said, what are the possibilities of this taking place and this being the unluckiest man? Thoughts, Aaron?
Yeah, well, I mean, a good argument's a good argument.
No.
And in a case like this, a super duper heavy circumstantial case with a good old-fashioned solid police investigation, even if the timing wasn't amazing, is like the right case. It's the right case. I feel like something's going on in the courtroom. Should I be listening to the courtroom or listening to you, Tanya?
Hold on a second. Let's listen for just a sec.
All right. Guess what? Y'all are the alternates, but y'all figured that out.
Oh, she's talking to the alternates.
I'm surprised they haven't killed the audio yet.
So we only have 12 people that deliberate. Y'all
I want to hear it.
wait.
Alternates.
Well, listen.
So what I'm going to ask you to do is you will be in a separate room from them.
Oh, I guess, well, because I think usually what happens is the judge wants us to kill the audio whenever we're off the record, so I'm guessing that's what happened. So, yeah, I mean, basically, you and I kept talking earlier about this whole unluckiest man concept, and I'd like to think that Glenn Fitzmartin, somehow heard us or heard about what we were talking about and decided to take that, but I kind of think that probably isn't what happened, but it's a pretty legitimate argument, right?
Yeah, definitely under these circumstances. I really also, there are a couple of things that I picked up on that both the parties said. I thought a really powerful argument from the defense attorney was, before you become 14, you have to be one. And of course, he's referring to 14, which is actually 12, because a felony jury is 12 persons. In this case right now, we have 14, though they're excusing the two alternates. So what I think Kobe Warren meant by that is he was really asking those jurors first to think as an individual before thinking as a community, like a community of jurors. And I thought that was a really good argument for him to make, especially when his whole goal is to try to create or isolate reasonable doubt in the minds of one or more jurors. So before you become 14, you have to be one. I'm going to remember that. But anyway, back to the unluckiest argument. I also heard the opening prosecutor, Mr. Varney. I felt like he really boiled it down to its most simple. If you believe he took her life in the course of taking her stuff, then he's guilty. And I mean, sometimes, like, when you boil it down to its most simple, it's the easiest to digest, and I thought that was pretty good. And Fitzmartin's first comments when he first stood up was that he had never been accused of bringing too much evidence, or however he said it, but he focused on, he was answering the argument of the defense attorney when the defense attorney said, quality over quantity, or quantity over quality, as the case may be. And Fitzmartin got up, the state got up and answered that pretty well with I got both. I got your quantity, I got your quality. So that was pretty good.
Well, because I think what Kobe was saying was, well, they just threw everything against the wall. They're just trying to overwhelm you with stuff, right? That's what he was essentially arguing. And the prosecutor saying, we gave you all this stuff because we had the goods. I mean,
right. Well, yeah, and I was kind of picking up what Fitzmartin was putting down when he said that, jurors, especially present-day jurors who watch TV and Netflix and listen to podcasts and expect lots of meat and potatoes in the presentation of evidence, he said he knew that they expected that, and he told those jurors, he's like, I don't know which one of you is it going to be. Is it going to be you? Is it going to be you? Is it going to be you? Who's going to be the one who said, I just wanted a little bit more? But you don't have to worry about that because they brought you a little bit more, and then a little bit more, and then a little bit more. And I feel him when he says that, because I know I have heard juries tell us after the trial's over with, on both sides, as a prosecutor for the state and as a criminal defense attorney, I've heard jurors say that exact phrase, well, I just wanted a little bit more. If you had just had a little bit more. So I feel like he was both responding to defense counsel, but also kind of trying to head that off at the pass, right?
Right. Oh, and I thought it was really important, from my perspective, all that information, all that testimony about these 3 victims. I mean, for me, that was really compelling. I don't know how you could, okay, so maybe, and that's a big maybe, you could buy a coinkydink, right? He's the unluckiest man to have Lou Harris's stuff, right? Maybe. But he's the unluckiest man with Mary Bartell, and he's the unluckiest man with Mary Brooks. I mean, yeah, I don't buy that.
Yeah, and Fitzmartin pointed out, these 3 women, they don't know each other. They don't know each other.
And he doesn't know them.
And he doesn't know them. And they don't know him.
I wrote down some of the things that Jerry Varney said. Jerry said his greed was more important than the life of Lou Harris. And he also said that, when you look at, and I just said this a little bit, that when you look at Mary Bartell, Mary Sue Brooks, and Lou Harris, it just that all these shows that this is just more than a coincidence. And I think that's why it was important for them to do all that.
Well, yeah, I mean, perhaps they had to do it. I mean, they may have had to have brought in those extraneous offenses in order to prove absence of mistake or modus operandi. Maybe they had to do that, but then at the same time, it did make it all make sense. And it did make it all make sense.
It shows an MO.
Oh, yeah. I agree.
That's right. You said modus operandi. See, you used the big word. I just think,
yeah.
I'm sorry. It was a big word. Sorry.
Yeah, most people don't speak Latin. I don't know why I said that. But I also heard Jerry Varney when he said that this guy, in his assessment, that Chemirmir saw these people as walking dollar signs, and he focused a lot on the greed over value of life. And I heard him when he say that the jewelry represented for those women, or maybe one of the women, or however he said it, love, life, and memories, but to the defendant, a quick paycheck.
Right.
And I thought, and that kind of, I didn't really think that the state needed to really use a lot of drama or emotion because they had such good facts, and I don't think that they did. I mean, they had the requisite amount. But that love, life, and memories. So
it's powerful stuff, and I think my both of my grandmothers are now deceased, but it is I can't help but think about my own grandmothers and how I would feel if something like this had happened to them. I would be devastated. Doesn't even begin to cover it, and then to know that they're these family heirlooms. We don't really have any family heirlooms in my family, but if we had family heirlooms, I could see like that being really hurtful. Your grandmother's ring. I mean,
well, and we try to teach our kids not to attach too much emotional value to like material objects, but at the same time, my mom gave our middle child this beautiful bracelet that my mom picked out for her from a faraway place because it reminded my mom of her grandmother and how her grandmother would travel and pick up jewelry and mementos. And anyway, so those things really do matter. And hopefully that little nugget of Mr. Varney's argument, the families of the deceased, I'm sure, are listening and are watching, and that probably meant something to them.
Absolutely, and it was interesting also, Jerry Varney also said, it basically, if I recall correctly, he said something like, not to get confused by the whole theft thing or burglary thing, he said, we are not here for a theft case where he happened to have some stolen goods. I thought that was pretty effective.
Yeah, and I might have expected for the defense to focus a little bit more on the theft thing, just to try to maybe dangle that in front of a suspicious juror who might bite. But really, I felt like what the defense tried to do in his argument was sort of scatter things about. I think the way you said it, Tanya, was that throw something on the wall. I would follow that with to see what sticks. But I do feel like he sort of scattered things about, and he suggested to the jury, wait a minute, I thought we were here about the death of Miss Harris, so why are we talking about Miss Brooks? Why are we talking about Miss Bartell? And you might have expected that the state would respond with well, you better believe we're talking about Miss Brooks, Miss Bartell, because they are all part of the pieces of the puzzle. And I think the way Fitzmartin answered that was, yeah, no, we're here because this is the case against Billy Chemirmir, and
right.
all of that is part of that. But I feel like that's what the defense lawyer did. I think he was sort of scattering things about intentionally, not in an unintentional or a scattered way, but sort of in a way to do what he set out to do, which was to try to convince the jurors that the state hadn't met their burden.
Right.
Yeah.
Well, yeah, he's basically saying, they haven't met their burden of reasonable doubt.
Right.
They haven't proven these women were killed. They haven't. I guess he's saying at best they've proven theft.
Yeah,
right?
and he said just because the state's admitted 300 pieces of evidence and they've called 30 witnesses, and the defense attorney made a very important point, which is that just because a piece of evidence is admitted or just because a witness testifies doesn't mean you have to automatically believe it, right? Because the jurors are supposed to be the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony and the evidence. And so that's really important, but it becomes rather difficult when you do have 300 pieces of evidence that all tie one to the next and to the next, and maybe 30 credible witnesses whose testimony all ties one to the next to the next.
Let's talk about so the jury has been sent somewhere. I don't know if it's the normal jury deliberation room or somewhere else.
I think that's where they are.
What's happening now?
Well, I think that's where they are because I also think that's where they are because your camera is looking at the jury call light, which in the event the jury has a question for the court or has reached a verdict in the case, that little light will light up hot red, and then everybody will know that there's about to be some action. So I think, I do think that the jury is back in the jury room around a big conference table, all 12 of them snuggled up next to each other. I imagine that they'll go back there and maybe there will be a quick restroom break or a quick snack or drink or smoke, as the case may be. And then I think that they will pick a four-person, and then they will either get right into it. It could go a number of ways. The jury could say, hey, let's just do an initial vote and kind of see where everybody is. The jury could be a bunch of firstborn children who all want to read the instructions and make sure they follow them, and they could all get out their copy of the jury charge and read it together. Or they may just start a conversation. It's going to depend on the personalities in the room, and if there's one or more take charge individuals who direct the conversation or direct the dynamics.
Right.
Or it could be a too many cooks in the kitchen situation, and it may not be real streamlined, and things may take longer than they might otherwise. So
there's really no, at least in my experience, there's no one way how things are done with the jury.
Right. Agreed.
I mean, it just they each have their own dynamic, and also, when they ask questions, how much credence or how much stock do we even place in questions that they asked?
Okay, well, so I think what you're referring to is when the jury as a group or as a whole sends a question to the court. Is that what you mean?
Mm-hmm. Yeah.
Right. So if there's a question and they communicate that, it has to be in writing and it has to be signed by the foreperson. Usually it's a question where they're at odds or in disagreement about a particular piece of evidence or a particular point in the testimony. And so they'll communicate that to the court and say, we want to understand whether Detective Tabor said it was this or it was that. But they have to be pretty specific. And I mean, the question you asked me was how much stock do we put in those questions? I mean, sometimes that can be really important. I mean, if a jury sends out a note and they're asking about standard of proof, or they're asking about how to navigate the application paragraph as it relates to considering the lesser included, for example. I mean, sometimes we put a lot of stock in that because we try to imagine what they're thinking and where they are in their process. Of course, we don't really know what they're doing, but I think it just kind of depends on the question. Sometimes they'll send out a question and ask whether they can take a break for a meal, and so clearly that's not that exciting. We all get real excited because the red light comes on hot, and then the question is, may we please have a snack break? So.
Exactly. Well, and really for the purposes of a jury, they've gone back at, here's about 4 o'clock. It's more than enough time for them to come back with a verdict today.
I think you could be right. I
mean, I wouldn't be surprised. It's Thursday afternoon. You know this. Juries, they're not going to be too thrilled to come back here on Friday.
Yeah, and it's funny, there are different schools of thought on that, whether a convicting jury sleeps on it or an acquitting jury sleeps on it. But there's no real science or data to those statistics. But